National Assembly. The Speaker of the National Assembly is the 13th respondent, and the National Assembly is the 15th respondent. My lady, I also join my colleagues and echo the sentiments that they have raised, that the Speaker of the National Assembly and the National Assembly were main respondents in both the High Court and the Court of Appeal. And we will also be requesting the court, my lady, that if, as it considers the time request made by my learned seniors, it also considers adding us a few more minutes. My lord, I represent two parties, the Speaker of the National Assembly and the National Assembly, and we were allocated 15 minutes, I think, for each party. And if that is the case, my lady, and the court is unable to see to the request for more time, we will be donating 10 minutes of our time, and my lady will be remaining with 20 minutes to highlight on our issues. Thank you.
It may please the court, my name is James Orengo. I appear for the 18th respondent and the 21st respondent, together with my learned friends, Mr. Paul Mwangi, Professor Ben Sihanya, my learned friend, Mr. Jackson Awele, Mr. Arnold Ochieng Oginga, Ms. Winfred Makaba. From our point of view, we fully support the remarks made on behalf of the two appellants, namely the Attorney General and the IEBC. It is our view that this matter should be fully ventilated. The matter, although being heard and considered by the court, but there's a great deal of public interest in this matter. The Kenyan people would want to know the arguments and the positions of the various parties as ventilated before the court. They don't have the privilege of having the written submissions. And my lady and the court, this is probably one of the most important cases that would ever come before the Supreme Court on the Constitution. Secondly, my lady, we appear for the two respondents. We filed joint submissions. In the submissions, you'd find that in respect of each respondent, the matters we are dealing with in respect of both respondents, some of them are common and others are not common. But I'd urge you that if you had to give the Attorney General 5 minutes, since we are appearing for two respondents, would be appreciated. Since if you look at our written submissions, we are almost dealing with all the issues that are being raised by the appellants. So we would pray that you give us 5 additional minutes, and that will only be possible if the Honorable Attorney General and the IEBC are given a little bit more time. Thank you.
Thank you, Chief Justice and Counsel. This is for Senior Counsel Martha Karua and Mr. Ochieng Dudley. From the record, your clients were admitted as amici curiae on the 21st of January 2021, so that you entered the proceedings at the first instance as amici curiae. At the Court of Appeal, you are partly named as respondents. In one appeal, you are named as amici curiae. The question that I'm asking myself is, when does amici mutate, stop being a friend of the court, and the court is the court, and then become a party either as an appellant or as a respondent. So that the question we're asking ourselves is, if you enter the proceedings, the dispute at the High Court as amici curiae, why are you suddenly calling yourselves respondents? Is it enough that the appellants called you respondents? Do parties create positions for themselves by suing each other outside the framework of the dispute before the court? And therefore, why is it in error for us to have said that you are amici right from the beginning until this court? That is where the issue would arise. And I think the error is admitted by the court, that in the you were joined as amici not at the Court of Appeal, as the directions would be saying, but at the High Court on the 21st of January 2021. So my question is, how do you mutate from a friend of the court to an adversary of one of the parties, as you're saying? That is all we're asking.
If I may, in the Court of Appeal, we were cited as respondents and accused of being partisan. We responded, therefore, as respondents and tackled the issues as respondents. The same before this court, and nobody challenged that. I remember in the Court of Appeal, it was put to us in the allocation of time, but we did tell the court, having been dragged to court as respondents, we deserve time to highlight and defend our position. In these proceedings, it's exactly the same. And before this court, we made an application for consolidation, which cannot be made by an amici. The court treated us as respondents. Can the court then turn us into amici? Because before this court, we now come to defend our position just like we defended it in the Court of Appeal. But our position also is that regarding every party before the court, including interested parties, this being the highest court, nobody should be shut out. Everybody should be given a hearing. But we are respondents, that's the way we are named, and respondents also, once heard by the court, we are not opposing any party. It is because our submissions appeared to agree with the submissions of one of the respondents that the AG and the others cited us as respondents in the Court of Appeal. The AG avoided us in this court, but we see his last submissions are mainly responding to our submissions. We deserve a hearing. And we are asking the question again, how does an interested party who then morphed into a respondent, just like us, get 45 minutes, and we don't mind her getting 45 minutes, but in contrast, we are shut out? Where is the equality before the law?
If I may also briefly respond to the question. We are victims of a situation which we have not created. The Court of Appeal Rules 2010 do not recognize amicus. I've appeared before you twice recently in the County Development Board's case, where a former amicus at the High Court was heard here as respondent. I also appeared before you in the Eric Gitari case, where a former amicus at the High Court ended up here as respondent and was given audience. That is the situation with all amici admitted at the High Court currently. And the other thing is this court's rule on amicus is that an amicus who is slanted to one side will have their submissions disregarded. So Jack Mimali right now risks being excluded from the oral arguments, and when you come to his written submissions, you'll find them supporting one side of the case. He also risks being excluded at that level. That danger can only be mitigated by allowing him about 10 to 15 minutes to highlight what his case is about. Thank you.
Thank you very much. We will consider those submissions on the allocation of time, and we'll be back after 20 minutes to proceed.